Hi everybody, Scott Nell here with the Scott Nell team. I'm here with Armine Bazikyan with the Bazikyan Law Group. She is an amazing estate planning attorney. Our question today, our topic today is, what are the pros and cons of tenants in common? So tell us, what do we need to know about tenants in common?
So it's actually a form of ownership in property, and the only requirement is that there be at least two people, right? It's different from joint tenancy, which is also a form of ownership in property with two or more people, because in joint tenancy, the people, when they take title, they agree that they each own 100%. So let's say Sam and Bob own property. If they owned it in joint tenancy, Sam would have 100% interest in the property, Bob would have 100% interest in the property as joint tenants. Versus in tenancy in common, Bob and Sam would actually specifically state what percentage they own the asset. So they could own it equally or unequally. So it's really a great form of ownership for people that are partners, that aren't necessarily purchasing their first home to live in, that are just purchasing a real piece of property as an investment. Right. Because then they can decide, hey, you know, let's go 50-50 or let's go 80-20. So it has that benefit, but it's literally just a simple ownership method where there's two or more people.
So someone passes away and it's 50-50, so the other 50% doesn't automatically go to the other person. What happens with the other 50% though? What determines that? So
this is the negatives of tenancy in common.
Tell us all the negatives.
And this is the reason why people don't utilize it as much as they utilize joint tenancy, because it doesn't have, by operation of law, a presumption of survival in there, which basically means that if Sam were to pass away, his 50% portion doesn't just automatically go to Bob. That 50% portion actually belongs to Sam's estate. So it would actually be funneled through the probate system, so it would go to court if Sam didn't have an estate plan in place, and it would go to his closest family members depending on what the scenario was. So if he didn't have any estate planning done, it would be kicked into the probate court, and his next of kin, according to California's intestacy laws, would actually inherit. Okay? Who's at a disadvantage here? Bob. Because he owns this property as a 50% owner, Sam's gone, and now he's at the mercy of the court. So if he wants to sell this property right away or mortgage it or do some improvements on it, he's going to have to work with Sam's administrator of his estate. So his hands are going to be tied with respect to something that he considers an investment. So Bob is the person that's really at a disadvantage. So if you do have two or more people that are investment partners, they should definitely have their own estate plans in place that would allow it to bypass probate and be administered privately within the family environment.
Okay, so do this for me. Let's say your family and my family, we find an investment property. We're going to buy it together. We know it's going to be 50-50. What are you going to do? You have your husband and your family. I've got my wife, my family. What would you be thinking if it was you would do in order to protect yourself and to protect the integrity of the project?
So first of all, I would take that 50% interest of mine and transfer it into my trust, so that I would make sure it would bypass probate and go according to the terms of my trust, whether that's to my husband or my kids, who cares, right? It's my decision. I can do what I want with my 50. The same goes for you. You should be doing the same with your 50. In an ideal world, we would actually form an LLC or some type of legal entity to segregate that property from us personally and to protect it. But if we weren't interested in any type of entity formation to hold this asset, then we would literally just make sure that your 50 is taken care of in your estate plan, my 50 is taken care of in my estate plan.
But let's say, I mean, hypothetically, if something were to happen to you and I decide, my wife and I, we decide, you know, we really want to sell, but your husband doesn't want...
Is the new owner. You better deal with my husband.
So we have to deal with your husband. Is he nice?
You know, some days. He's a litigator. Good luck with that.
Oh no. Okay.
Yeah. So that's really, the problem, right?
So if you have an entity, it might be a safer way, because then it would tell you what happens under different circumstances.
Exactly. And ideally, in the ideal world, when you do have that type of investment deal happening, you have a buy-sell agreement in place. You should, before the death actually happens or disability or whatever the event is, you should sit down and talk about what happens. Hey, if I get a divorce, I don't want my husband to have any say in this, so let's engage in a buy-sell agreement where we can actually dictate what happens in that scenario. What happens in a situation of death? Is my husband obligated to offer it to you first before he goes out and sells it to a third party?
Right.
And these are all questions that ideally should be addressed ahead of time. Most of the time they're not.
Now, is that something that an estate planning attorney will handle? Someone like you would be able to handle not only the estate plan side of it, but the entity side of it as well? Or how does that work?
It depends on the estate planning attorney. So yes, for example, our firm handles the estate planning side, and then if there are asset protection concerns, the clients want to establish, an LLC or an entity of some sort to hold the property, we would assist them with establishing that entity and then integrating it within their estate plan. And the same goes for the buy-sell agreement. If they are open to creating a buy-sell agreement or some other agreement form between them to cover these different scenarios, we would be able to assist them.
So I know we're going off topic a little bit, but when you say a buy-sell agreement, can you tell us what a buy-sell agreement is?
It's literally an agreement between the partners of an entity. Let's say it's a corporation or an LLC. They sit down and they hash it out. They basically talk about death, so they talk about different events in life that would trigger certain things to happen.
Okay.
It could be a buy, it could be, it could be whatever they want it to be. So it's basically like Sam and Bob would sit in a room and say, hey, if I'm disabled, I still want to keep this property, but instead of giving me the income or whatnot, like make sure my family still gets the income.
Right.
A disability is not a buyout event. Or they could say a disability is a buyout event. It just depends on what their, it's basically an agreement between partners as far as addressing what happens.
It seems like the possibilities are endless. How do you address everything? Do you have like a checklist? And I mean, I can imagine you sitting down for hours and hours going over every possible.
So usually it's a few categories. It's disability, death, divorce. So it's
the biggies.
The biggies, yeah. The big Ds, we call them. But it all depends on the people and their interest and their relationship together. Like you mentioned, some people don't want to be partners with, they might like you, I might like you, but I don't like dealing with your family members.
My wife's lovely, by the way.
I've heard.
Just so you know.
But some people don't, they agreed to be partners with this person, not the person that would take charge if the person were to pass away. So it's very important to kind of talk about all that.
Perfect. Excellent. That's great information.
Yeah.
Very good. Hey everyone, if you'd like more information about myself or my amazing team, check out scottnellteam.com or subscribe to our YouTube channel. Thanks for watching.